Excellent. Thank you all. There are several dozen people who appreciate our patience here so they could join digitally, and welcome. Indeed, thank you to everyone here and on Zoom for joining. Since 2014, one of the defining events here at Arizona Law has been the Peter Chase Neumann Civil Justice Lecture, which is a foundation of our Civil Justice Initiative. The goal of the Neumann Lecture is to explore the power of law to advance justice for individuals, for communities, and for our country through the civil justice system. This year, it is a particular pleasure as we celebrate two lawyers, both extraordinary advocates, both highly regarded in the profession, both deeply respected in their communities, and both Arizona law grads. Their long and productive legal careers embody the goals of a just, dynamic, and efficient civil justice system. The alumni we celebrate today are Peter Neumann, whose generosity created the lecture series, and our speaker, J. Michael Hennigan, whose career as one of the nation's great litigators has been devoted to civil justice. Mike Hennigan demonstrates the potential of advocacy to change minds and shape outcomes. He is a lawyer's lawyer, willing to take on the most challenging matters. And Mike and his wife, Phyllis, have been great friends to this university, to our college, and to me. I was so pleased when their grandson, John Michael, now a deeply engaged sophomore, chose to attend the U of A. I will give a brief introduction for Peter, who will then, with alum Shauna Ballard, provide a fuller introduction for Mike. Peter graduated from Arizona Law in 1964 and began his career as a criminal defense lawyer, and then moved to the Pima County Attorney's Office as a prosecutor. In 1968, Peter and his soon-to-be wife, Renate, I think I have the timing right, moved to Reno, where he maintained a prominent civil plaintiffs practice for many years and became an active participant and leader in the Reno community and indeed across the state of Nevada. In the early 1970s, he was one of the first Nevada lawyers to win a multi-million-dollar damage verdict for his client. He has represented victims in air crashes, defective consumer product failure cases, including a number of famous cases against the AMC Jeep CJ5 for its proclivity to roll over and harm its passengers. He's also handled a number of insurance bad faith cases. Like so many plaintiffs' lawyers, and of course, lawyers in other fields too, Peter's interest extends to politics and public policy. His passion for the pursuit of justice includes the broad protection of civil rights. On a more personal level, he's a lifelong pilot of both planes with engines and those without. And I'm not talking about planes that had them stopped working and he represented those harmed. I'm talking about gliders. He flew a powered plane, his own plane here from Reno, to attend this year's Neumann Lecture, and several years ago made it possible for me to spend a glorious afternoon, well, glorious for me, a little terrifying for my wife, in a glider, which was one of my life's goals. Please join me in thanking Peter, who will, along with Shauna, introduce our 2022 Neumann lecturer, Mike Hennigan.
Thank you, Dean Bill. I'm going to be very, very brief because I want to hear Mike Hennigan even more than probably you do. And it's a real honor for me to be here and introduce him. But I'm going to hand the ball off to another good lawyer, great lawyer, Shauna Ballard, who probably knows Mike professionally as well as anyone. And I'm hoping she'll have some good stories for us. I just want to say that I admire everything I've read about Mike. I didn't know him, I didn't meet him until I got here yesterday. We had a delightful dinner last night, and he's going to be great. And the one thing I do have in common with him, besides being a trial lawyer, although my trial lawyer level was like down here and his was up here, was that we were both Fuller Brush men when we were in college. So I think that speaks to persuasiveness and the ability to communicate with people. And I was very interested to know that he was a Fuller Brush man, as I am. So I'm going to have attorney, lawyer, trial lawyer, deluxe, Shauna Ballard, say a few remarks about Mike because she's kind enough to do so. And thank you very much.
So I'm also a University of Arizona Law School alum and had the pleasure of working with Mike for about 22 years. He's my mentor and someone I looked up to. I think his bio, speaks for itself in some respects. 45 jury trials, $8 billion in recovery for his clients. And I want to give a little bit of context of these are hard-fought cases. These weren't easy cases. Think of the papers. These are the things you read about in the papers. The S&L crisis. Mike's got a major role in trials. The first municipal bankruptcy in the country. Mike led the team to recover $880 million for Orange County from investment banks that had convinced the county to go into some wildly complicated and unfortunately not very fruitful investments. The Enron financial collapse and crisis represented major positions, over $1 billion worth of positions in the Enron financial crisis. Just for context, the documents, if they had all been printed out, produced in that case, would have filled the 10-story building. The deregulation of the California energy markets. Mike did numerous trials for Sempra Energy in the aftermath of the deregulation, subprime crisis, the things you read about in the papers is what Mike was in the middle of and in these 45 trials against some of the best lawyers in the country. And, going to the jury trial phase of it, there's probably a lot of secrets to, Mike's magic, but part of it was he could read the room, all parts of the room, the jury, the witness, the judge, and could react, had an intuition to how to react to what was happening. No cross-examination, no trial presentation was the same. And really the guts to do something about it. When you've got tens of millions of dollars on the line, hundreds of millions, to retriangulate and make a shift because you feel something happening at the moment, it's not an easy thing to do. It seemed that we never, after years of pretrial, we somehow didn't always try the case we thought we were going to try. When we got to trial, we would, in that 2 weeks before getting ready, Mike would have some brilliant insight and we'd come in and the case would shift. I always teased him that he seemed to have this innate sense of getting bored about the same time as the jury. But what I really meant by that is he would feel it. He knew we'd done enough. We were winning. It was time to sit down. Now, that was much the terror of those of us who thought maybe we should call that expert or that other witness. But, no, he knew it was time. We were winning. Let's sit down and close our case. And of course, as a trial lawyer, he was the art of cross-examination. I can't even quite capture it other than, think TV movies, TV shows when, the key witness is on the stand and at some point there's this climax where it becomes apparent to everyone in the room what the real backstory was, what was really going on that wasn't written down. Those were the, most trials, that would be the culmination of the trial is Mike's cross. And, our cases might have been, might think, dry financial transactions, but there's a human story under them. And what Mike was able to do is, sure, table stakes, describe that complicated finance transaction, a reverse derivative and why that was wrong. But what he did with the jury was to tell the human story, the right and wrong, and to connect with the jury in a compassionate way and with conviction in a way that really only Mike could do. So let's hear from the person, and I introduce Mike Hennigan.
Got this little button to push. On.
Wow. Who is this guy? I hope I'm funny. You will learn that I have this initial lecture talk in 5 parts. And if I get done in time, after that, I'll give you a hint on how to pass the bar exam. And the reason I'll do that is because the guy who gave me the hint is here, Professor Winton Woods. Okay. Number 1. This is you, first person singular. I, me, look like a lawyer. We don't have an official dress code, but we have an unofficial dress code. Pay attention, pick it out for your own taste, but pay attention to the lawyers in the courtroom who are effective and dress like they do. Number 1, still number 1, I'm going to tell you about my first jury trial. I graduated from law school, went to work for the Justice Department in DC, worked 2 years there in the antitrust division, had lots of motions, lots of interrogations, ran grand juries and things like that, but I never saw a jury. Came back and went to work for Snell and Wilmer in Phoenix. And my first jury trial, I was asked by the senior litigator, John Bauma, to prepare a case for trial. And one Thursday, he came into my office and said, "How's that case going?" I said, "Pretty well. It's starting trial on Monday." And he went, "What?" I said, "Yeah." And so that Monday, he worked the weekend. That Monday, we went to pick the jury. I'd never seen a jury pick before. We were defense, so I got to see the first guy, and then John Bauma picked the jury. We went then to lunch, and on the way back from lunch toward the courthouse, John says, "I think you better open." I said, "Okay," and went right to the bathroom. So I got to see the plaintiff open, and then I opened, I think probably inartfully, but we wound up winning the case. So the okay with that. The second thing we're going to talk about is victory. I've heard people say that the only 2 good things about being a trial lawyer are winning and talking about trial law with other lawyers. So I'm going to do the second part here. One of the keys to winning in the courtroom, besides, I'm going to go back to number 1 for a minute. Sorry. You're going to dress like a lawyer, and you're going to have an attitude like a lawyer. Peter said correctly that we were both Fuller Brush salesmen. I don't know if you've ever even know what a Fuller Brush salesman does anymore, but we go door to door and knock on doors and say, "Hi, would you buy this?" And there are days when it's hard to get out of bed because you get a lot of doors slammed. You got a lot of, rushing off the porches and things like that. But you keep going. Now, I had a client who was a motivational speaker. And his claim to fame was he's made $100,000 one year selling knives door to door. Really? And he would tell people, "How do you do that? How do you get up in the morning on a dismal series of calls? And how do you get going?" And he said he does this. He walks into the bathroom, grabs the sink, looks in the mirror and says, "Get out there. They've got your money. You've got their knives." Now, I'm not suggesting that you necessarily need to do that, but when you are in court, your attitude and the way you bear yourself and the expression on your face is part of what makes the case winnable or not. You've got to figure out a way to look inside yourself and do that. So 2, winning and that. 3, when I try cases, I try them on my fingers. Main themes. Theme number 1, theme number 2, theme number 3. It's where I open. It's what I typically use in voir dire. It's what I close with. I frequently examine witnesses with this consistency. Generally, I think it works. I knew it was working one trial a few years ago when my opponent came about halfway through the trial with exhibits of my fingers. and he would start interrogating witnesses saying, Mr. Hennigan's point number 1 is this. Point number 2 is this. I figured we were winning, and indeed we did. We did. Number 4. 4, these are jurors. Obviously, we have more than 4 jurors. Sometimes we have 6, sometimes we have 12, sometimes we have 14, but they're the jurors. You have a relationship with them. Whether you like it or not, you have a relationship with them. They watch you. You watch them. You need to have a relationship with all of them. There are going to be some that are readily get your attention and you can talk to, and there's some that don't. Those are the ones you sort of focus on. And over time, you'll find that usually they come around. Usually they come around, but all through the trial, in the hallway, when the other side's talking, when the judge is talking, you're spending some time with a relationship with a jury. Number 5. Takes 5 fingers to pick up your notes. Put them down. Don't use notes. I'm not saying you can't turn them over at the end to see whether you missed something, but don't use notes. It will interfere with your spontaneity. It will interfere with the effectiveness of your presentation. And in the end, if you take a minute and have to look up your notes and look in, it won't hurt you. That's one of the keys to being a successful trial lawyer. It's a pleasure to do it. It's an honor to be part of that system. It's a wonderful profession. I was telling someone today when I graduated from this law school, I had no intention of being a trial lawyer. The lawyers that I'd seen try cases were downtown Tucson, not impressed, went to the Justice Department, wanted to be a appellate lawyer, but they stuck me in a trial practice. And after 2 years of that, all I wanted to do was work in a courtroom. So I'll take a question, or I'll move on to how you pass the bar exam. Yes.
What I do, and I want to ask you about this, is don't look at your notes. I will get the little stickies that are the square ones. I'll write one word on there that's the theme. When I'm doing the prep work, I'll put them up on like an easel and move around. And when I go in there with that witness, everything is on one sheet of paper with one word on it. And you can just glance at that and make sure you cover all those points. And that seems to work for me.
Yeah, and I got no objection to that at all. I'm going to tell you a little note story. I was intended to do this in the main theme. In fact, I've got two stories to tell you about that. I'm trying a long case in federal court, and I've got a very strong client on the stand. And my opponent gets up for cross-examination, and I can look over and see that he's got a list of questions. And he starts with question number 1 and goes to question number 2 and goes to question number 3, and he's just getting killed. And he goes to question number 4 number 5, and just keeps going. We won that case. And he was not a trial lawyer, except for that day. My other one is my second jury trial. I was lead after my success with my first one. And my second in command was Mark Wilmer, the name partner in Snell and Wilmer. He was older, not quite as old as I am right now, but he was not first chair any longer. He wanted me to be first chair. We were in Kingman, Arizona. Jury, we had a Phoenix judge, water law case. I opened. Mark was going to take the first witness. We call the witness. Mark Wilmer says, name? Thank you. Where do you live? Thank you. No further questions. He comes back, sits down. I go, what was that about? And he said, his words, I apologize for the language. He says, he's going to piss backwards. You just watch him. And sure enough, this guy was not our witness. He was not the guy that we'd prepped. And he was all on the other side. But because Mark had done what he did, they could no longer ask him leading questions. They had to wait and call him in their case, and then we could cross-examine him. An act of, I thought, genius. And while I have cut off examinations many times, I've never done that quite that way. But it's an amazing life. I have to say that my decision to pursue justice in the courtroom was a great one for me. I think my family has appreciated every moment except when I was actually in trial, when I can hardly think or talk about anything else. But there you have that. Yes.
Students here, some law students. You learn the rules of evidence in the classroom. Tell them how you really learn the rules of evidence in the courtroom.
Is what?
How you really learn the evidence in the courtroom.
Yes, you do.
I mean, it's all different.
Yes, you do.
You're in class. It's not bad. It's just that it's a different thing that happens once you get into court, and you have to just learn to be yourself, right? You can't
Indeed,
relate to
indeed.
some other lawyer.
And like I still told you in the beginning about get out there, they've got your money. The attitude that you bring to the courtroom, the way you stand, the expression on your face will often determine the outcome of an objection, and very frequently of an examination. You'll intimidate them, and there's no substitute for it. If you're insecure, it'll show. You got to figure out a way to get through that. You don't need to do the screaming part, but it might work. Get in there. They're trying to take your case away from you. Oh, and one other thing that I promised my team here I do is you have a relationship with the judge, the jury, and your opponent. Your opponent is not your enemy. He's sort of your enemy, but he's not a bad person because he's your opponent. You can be nice to him. You can be polite in the hallway, and eventually you're probably going to settle with him anyway. So remember that part too. Yes.
I don't want to be presumptuous, but if you've ever lost a case,
What?
if you ever had, when you reflect on that, did you just think to yourself, well, they just had a better case? Or if you look back over your career, do you think, well, here are the reasons why?
There's a famous lawyer in Phoenix, Fenimore Craig von Amen in Udall. It was Phil von Amen. And we were walking into a court together to start a trial. And he turned to me and said, Mike, you ought to settle this case. I said, okay. He says, I've never lost a case. I said, I've had clients lose cases. With my losses, which were not too many, gratefully, do I learn from them? I try to, but mostly I'm just suppressed. It's like I said, the two good things about being a trial lawyer, losing is not one of them. Yes.
What sparked your desire to go to law school originally?
Well, interesting. When I finished undergraduate school, I worked for Fuller Brush, wherever we are. And then that was during undergraduate school. When I finished undergraduate school, I went to work for IBM. IBM, in those days, you probably don't even know this, the young kids don't even know what it does. It was the major computer manufacturer in the world. And my territory was downtown Washington, DC. And I had to sell computers to people who didn't even know what they were. And so I spent a year being trained. I'm going to come back to another point, actually. Thank you. And at the end of the year being trained, then I went into the field for a year, and I was successful enough to make enough money to come back to law school, which I had decided I wanted to do. So I hadn't made up my mind until I decided I didn't want to sell computers sort of door to door until otherwise. But it's yes, a great decision.
It happened.
It happened. What was that other thing I was going to say?
IBM asked for the order.
Yes, thank you. And that blends into another topic. That's my daughter, Cassie, by the way, who helped me with my notes. At IBM, in your first year, you learn how to program a computer. You knew how to do business applications. You know how to do general ledger accounting, all kinds of stuff. The last week is sales school. You got to walk in the last exam, as you walk into an office, it's an IBM executive, but he's got a script. He's an XYZ executive. They manufacture something. You're going to walk in there and you're going to get all kinds of objections. Can you overcome their objections? And they tell you when you walk in, if you do one thing and don't do anything else right, you'll pass. What's the one thing? Ask for the order. Ask for the order. And out of a sales class of 20 or so, fewer than half were able to do that. In the pushback that you got from these hypothetical potential customers, they just couldn't get around to saying, will you buy it? And that gets me to this point that I forgot. Thank you, Cassie. Ask for the order. That means when you're talking to a jury, you don't just say, I want your verdict. You say, give you an example. I did 4 mock trials for this one jury consultant against a very capable lawyer from Latham and Watkins. And in each case, I asked for a number. And in each case, they gave me a little less than I asked for. But each time I asked for more. And each time they gave me more than I'd asked for the time before, right up to the last. I don't know how far I could have gone, but in real time, there was a case that I tried a couple of years ago. I had two clients. And when I went up to the jury, I said, you've not heard an expert witness tell you what this judgment ought to be. It's up to you to decide. But I wouldn't be doing my job if I didn't tell you what I thought the case was worth based on my experience. I said, I think this case is worth $2 million. They go out, deliberate for several days, come back, and they come in with $3.7 million. And they came up to me afterwards and said, we're sorry, we just couldn't get there. They thought I meant a piece. They thought I was asking for 4. And yeah, like that. Yes.
To answer your question on the wife, he suffers when he loses. Gratefully, it hasn't been often. But one of the bigger cases that he lost, he was tragically bereft. And interestingly, within a few months, the person who he had lost to, the client, called him up and asked him to represent him in his next case. We'll go back to the lawyer. They did win that one.
Ready to go on and pass the bar exam? No?
No, not quite yet. Mike, I'm Barbara Bergman. I'm the Director of Advocacy here at the U of A. And I'd like to know, what did you find most challenging about being a trial lawyer?
I think it all blends together. I think that the biggest challenge, I think, is to simplify cases. You know, this thing I'm talking about, three points. I use 3 points. Can it be 4? Yeah. Can it be 5? Don't do 5. You know, sometimes you can blend them together to have 3 be like subparts or something like that. But the whole idea about takes me a long time. There are days when I didn't know what my 3rd point was until the morning of opening statement. But then it was. But no, I think no, there's a magic to it. And when I talk about talking to the jurors, there's this one case I did where gratefully we didn't need a unanimous jury, but this one guy, I just couldn't connect with him. They went back, they deliberated for 30 days and it came back in 11-1. That guy, that guy. So I couldn't persuade him. They couldn't persuade him either, but that was enough. So.
Another question.
Yeah.
So can you give an example of, a case where you kind of had to re-triangulate and change the case theme, maybe on the eve of trial, the middle of trial, maybe one that I've heard from you, but I wasn't there for, might be the Greenback Disney case.
The what?
The Greenback Walt Disney case, the Disney case. Where I think you had to redo everything on the eve of trial and how you came about that.
I gratefully don't remember that.
I remember your story.
Peter.
Mike, why don't you talk about, since settlement happens a fair amount of time, your philosophy on how to settle the case?
Well, usually there's a client involved. So it's usually to shore up the client, to get him to be more optimistic. And as I tell my partners who off to try cases now, try your winners. If it's a winning case, don't give up easily. If you're going to settle if you have to, while the jury's sitting there. But the other side is going to see it the same way you do, and they're going to keep coming up until they do it. I think, like I said, it's a challenge. We settled a case this last week for a union in San Diego, and we started off with against a big finance company, and then we started off with their offers being like 1/3 of the damages. We wound up settling it last week for 120%. And we were nowhere near trial. I mean, the word trial had not even come into play, but at that point, our client couldn't turn that down.
There's a lot been written in the last decade or so about the disappearing civil jury trial. Do you have any thoughts about that?
I can't, I'm having trouble hearing.
Do you have thoughts about the disappearing jury trial?
Well, certainly COVID killed jury trials in Los Angeles and California for a couple of years. And it's still having an impact. I mean, the idea of gathering people together to listen to it are very challenging. Yes.
But even the move for arbitration or under the Federal Arbitration Act is that there's almost no end in sight to those.
Yeah, probably there's probably going to be more arbitrations. I'm right now defending the Catholic Church in Southern California. We have over 300 cases filed, and we think before the statute runs, we're going to have another 300 or 400. And we're working with the judge to sort of say, what are we going to do with this? If they don't settle, we're going to try 600 cases. And so in that case, I think the answer is we're probably going to mediate them all. But I've told the plaintiffs that we're going to settle the last case the same day we settle the first case. And we're not going to, we may try them all, or we're going to settle them all, but we're not going to settle any until we settle them all. Yes.
Mike, I wonder if you'd talk about voir dire of prospective jurors and what your thoughts about that are. Maybe give us some tips.
I didn't hear the first part.
On the voir dire of prospective jurors process. Of course, in federal court, so many federal judges don't even allow it, which is why I always like to be in state court. But some federal judges do allow it, and the state judges vary quite a bit as to how much they'll let you get away with in speaking to a prospective.
I've never had anybody shut me down. Although, in federal court, you got a much limited time period to talk to them. But I think the trick is to ask them questions that are likely to bubble up internal feelings, not necessarily about your case, but just in general. And look, we did a mock trial of one of our clergy cases a year or so ago. And we had 12 jurors, and we got to watch them deliberate. And one of the jurors wanted to give $30,000. One of them wanted to give 30 million. And how do you tell when you're doing voir dire one from the other? And the answer is, I don't have a formula for that. You know, it's part of my thing about your relationship with them. Look at them, you know, how are we doing? How do you feel about me? You know, it's like, and try to make friends with him. Like the one where the jury deliberated for a month, I never could make contact with him. I knew he was not going for us. Gratefully, it was just him.
Mike, can I have a follow-up to that? I don't know if you're aware of this, but the Arizona Supreme Court, as of January 1st, eliminated all peremptory challenges in state court in Arizona, both civil and criminal. What are your thoughts about something like that?
I think I'd go someplace else. It's, I did not know that, but oh my God.
There were a lot of people here who had that reaction too.
Well, I would think both sides would be equally concerned about that.
Mr. Hennigan, I'm monitoring the chat from Zoom. We had some questions coming in, one from Professor Cohen, who wants to know if you have any general preference between federal court and state court, and similarly, if you have preferences between bench versus jury trials.
I like jury trials, and federal versus state. Right now, it probably depends on who's going to get to trial. I've tried a lot of cases in both state and federal court, like them both. Part of it depends on the judge. So if I like the judge, you know, I go one way versus another, but no, I'm ambivalent. Okay, want to know how to pass the bar exam? Okay, the year is 1970. I'm here, not here in the law school, where the law school used to be, and I'm prepping for the bar exam. I'm also trying to get the last edition of the law review out, which is taking up all my time. And I'm a little stressed because I haven't had a chance to really review all the courses that are covered on the bar exam. I'm walking probably stressfully down the hallway when Professor Woods looks at me and says, "What's wrong?" I said, "There are a couple of courses here that I haven't been able to really master." And he said, what are they? I tell him what they were. Trust in the states or something like that. He said, "Shouldn't be a problem." I said, "What?" He said, "Look, you've been in law school for 3 years. You can spot an issue. read the question, say the issue is, and pick out whatever issue you see. Judges have held, because you know that there's probably a court that ruled that way some way. Other courts have held the other way. The better rule is that way. Went into the bar exam. I can't tell you how many questions I answered that way, but it was several. It was several. So I go back, I'm in DC at the time. So in those days, no online, just had to call up. And so when the day came to see whether you passed or not, I pick up my Justice Department phone and call the Arizona bar, say, hi, name, Mike Hennigan. She goes, long pause. She says, Mr. Hennigan, the executive director wants to talk to you. So I pause. He comes back and says, Mr. Hennigan, congratulations. You got the second highest grade on this. On the thank you, Woody Woods.
All right, I gotta tell a story about it. The U of A, when he first went to work for Stella Wilmer, the U of A set up a trunk line. Most of you guys probably don't even know what that is, but Mike and I were able to talk together almost every day. And after about a year, he said to me one day, I've really got a problem. I've got too many clients and I'm going to raise my rate from $50 to $100 an hour to cut down on the number of clients that I've got. A couple of months later, we're on the phone. He said, it didn't work. I got more clients than I had before. And I think he's over $100 an hour.
It's true. Think of that. Think of that. Okay, thank you.